to take a moment to talk about the importance of funding a trust. When you go to an estate planning attorney's office, a very common estate planning tool to avoid probate is referred to as a revocable living trust. But there are other types of trusts that might be involved as well. There's irrevocable trust, Medicaid asset protection trust, special needs trust, and all these trusts are going to have something in common, which is when the lawyer presents you with a stack of papers that you get signed, typically in their office, with our firm, it might be in our office, or sometimes we'll send one of our mobile notaries out to you if it's for your convenience. And you have two witnesses and a notary, and you get it all properly executed, and that's great. Now you have a fully executed, valid trust of whatever type, and it still remains a stack of papers until you do something with the trust. And what you'll often receive with your trust, which might be, let's say, 30, 40 pages long, is you'll get a 2 to 3 page document called a certificate of trust, which is simply proof that the trust exists. The Florida statutes say that third parties need to honor, and they don't have to ask, except for very limited circumstances, they're not allowed to ask for a full copy of the trust. This is to maintain your privacy. But when walking into a bank or an investment firm or dealing with an IRA custodian, you now have to figure out whether you're going to take the account and transfer into another account in the name of the trust, or retitle the existing account in the name of the trust. Or there are certain assets like life insurance policies and retirement accounts where your only choice is to name someone, and it can be the trust, as the pay-on-death beneficiary or the transfer-on-death beneficiary. For example, life insurance and IRAs, they must remain in an individual's name. They are not allowed to be owned by a trust outright, but the trust can receive the funds after the individual who owns the account passes away. So with all these accounts, you're either retitling the account into the name of your trust, or you're listing the trust as the pay-on-death beneficiary. And there's a lot of debate among lawyers, even with non-retirement accounts, like just regular bank accounts that you might own with a spouse, whether or not you want to retain ownership as an individual and just name the trust as the pay-on-death beneficiary, or if you want the trust to own the account right now. And I'm going to get into that in another video. But for this video, what I'm trying to convey is the bank needs to know that the trust exists. The bank needs to know that they're either naming the trust as the pay-on-death beneficiary or retitling the account as the trust being its owner instead of in your name individually. And this doesn't happen by magic. This doesn't happen automatically just because you have signed the trust. You have to affirmatively take the trust or the certificate of trust, which is that smaller document I was telling you about, and you have to affirmatively bring it to the bank or bring it to your financial advisor and say, how do I get this account to be named, to be transferred into this trust? Or how do I have this trust listed as the pay-on-death beneficiary in each account? Your Bank of America, your Citibank, your Chase, your Morgan Stanley, your Ameriprise, your UBS, right? Wherever it is you have money, all those institutions will have paperwork for you to fill out. That's very quick. They do it 1,000 times a day. This is like no big deal, but there is things you need to do after you have this trust signed at your lawyer's office, at your estate planning attorney's office, okay? That's called funding the trust. With real estate, what we will almost always do is if there's real estate involved and you want the trust to own your real estate, we can prepare a deed and we can record that deed, and that's how we get the real estate into the trust, because it will be in the public record that the trust owns this piece of property. In Florida, the trust can still remain your homestead. Non-homesteaded properties can be placed into a trust. We sometimes talk about placing non-homesteaded property into LLCs. That's for another conversation. But if we have a trust, we want to utilize the trust, we got to get the assets into the trust by some mechanical action. With real estate, it's a deed. With financial accounts, it's going to the financial institution and filling out their paperwork so that they have it on file that the new account owner is the trust, or the trust is listed with the financial institution as the pay-on-death beneficiary. I hope this helps. If you have any questions about estate planning, Medicaid planning, probate, how to properly fund your trust, if you're a client of ours, we walk you through this very, very step by step. We give you written instructions, we give you verbal instructions. We're sort of holding your hand through the whole process, but we'd be happy to be of service anywhere in the state of Florida. Thank you very much for watching.